Hello, thank you for clicking on this video. I'm Dean Rod Vera, and today we'll talk about the Andal versus Andal case, which gave significant changes to the rules on annulments. Welcome back. Again, I'm Dean Rod Vera. I'm a law school dean and a litigator once in a while. Today, I will discuss the implications, the effects, and the changes made in the rules of annulment with regards to Article 36 of the Family Code. The Family Code was enacted in 1988, and one of the groundbreaking provisions there was Article 36, which stated that a marriage will be considered void if one of the spouses has psychological incapacity. And it establishes that there was no definition of what that was, and it was left up to the courts to decide on how a marriage can be considered void or invalidated based on one of the spouses having difficulty or non-fulfillment of the marital obligations. First, I will discuss the primary conditions of what is an annulment as compared to divorce. First of all, we have no divorce in the Philippines. And in divorce, a marriage is considered cut or severed based on conditions that are existing within the marriage. In a way, if you look at it, divorce is like a win-loss record. The game has been played and there was either a win or a loss. But we all know at this point, a divorce, there is no winner. Now, in annulments, what it really means is you are annulling or you are disregarding the marriage. And when it is annulled, it is as if it never happened. Of course, on paper. That means either the game was never played. It's not even forfeit, because a forfeit presupposes that the game has been played and there was not enough players. And it's recorded as a win for the person who was not in forfeit. Enough of the sports analogies. Article 36, or the rule on psychological incapacity for annulments, came in 1988. The Philippine Supreme Court first dealt with this issue in the case of Santos in 1995. And the jurisprudential doctrine in that case was for psychological incapacity to be a ground for annulment, there must be three conditions within the marriage, or at least within the psychological incapacity. It was gravity, antecedents, and incurability. Those were the three requirements that the court said must exist or must be present or at least proven in the petition for annulment of the marriage. So whatever was the psychological incapacity, the court said that it must be so grave that a spouse, the guilty spouse, is doing it so much and the innocent spouse is the victim of the incapacity. Second, it must be antecedents, or it must have occurred at the time of the celebration of the marriage. And lastly, the court said it must be incurable, meaning there was no hope for the guilty spouse to get rid or to be cured or to be healed, if ever, of the psychological incapacity. Then, in 1997, as every law student will dread, was the Molina case. In the Molina case, the Supreme Court expanded the rule on Santos. It gave at least 8 guidelines or 8 rules for a court, or the regional trial court for this matter, to consider in deciding whether a marriage is subject to annulment based on psychological incapacity. Let me show you those 8 guidelines. First, it is up to the plaintiff or the one filing the complaint that must prove that there is psychological incapacity on the guilty spouse. The burden of proof to show what the psychological incapacity is upon the shoulders of the one filing the complaint. In other words, the innocent spouse. Because the innocent spouse is claiming that the guilty spouse has psychological incapacity. The second guideline, to paraphrase it or to summarize it, is that the psychological incapacity must be medically proven by experts. Meaning, a psychologist or a psychiatrist must make a finding that the guilty spouse is indeed psychologically incapacitated in the marriage and is not able or cannot comprehend the marital obligations that come with a marriage. The third guideline or the third rule given by Molina is that there must be juridical antecedents. As again, as in Santos, it must have existed or existed at the time of the celebration of the marriage. The fourth guideline, again, is to reiterate Santos, is that the psychological incapacity must be incurable. And the fifth guideline, again, or rule, to reiterate Santos, it must be grave enough, or there must be such gravity on the guilty spouse. Molina then added two other guidelines or rules for that matter. The sixth guideline, which was added in Molina to emphasize the Santos doctrine, was that the guilty spouse could not fulfill or did not fulfill the essential obligations both as a husband, obligations as a spouse and a parent to the children. The family code in the Philippines lists several obligations that a spouse has to another spouse and the parent has to their children. So the court said there must be proof or showing that the guilty spouse did not or could not fulfill the obligations mandated by the family code, either as a parent or as a spouse. The seventh guideline was a bit controversial. It stated that since Article 36, psychological incapacity, was founded on Catholic rules of annulment, or the Catholic Church's rules on annulment, the interpretations of the National Appellate Matrimonial Tribunal of the Catholic Church will be given persuasive effect. I think this should only apply to those marriages that were solemnized in the Catholic ritual. The eighth and the last guideline was that the prosecutor, or the fiscal if you will, must appear as counsel for the state, not necessarily as an adversary to anybody, but mainly to protect the general rule that the state must protect the sanctity of marriage. Now, in May 2021, the Supreme Court of the Philippines promulgated the decision of Andal versus Andal, or for short, the Andal case. The decision is quite long. It's about 54 pages and there's a lot of explanations, and the majority of which told the story of the Andal spouses on how the husband was considered the guilty spouse and was not able to fulfill or was shown to be psychologically incapacitated. The court was filed in Parañaque. The regional trial court, in this case, found that the marriage was indeed or should be annulled because of psychological incapacity of the husband. The kicker here is that the Court of Appeals, on appeal by the state, reversed the decision of the Regional Trial Court of Parañaque, stating that the facts of psychological capacity was not proven sufficiently. Because in the trial stage, what happened was the psychiatrist that was considered as the expert for the case did not interview the husband. Therefore, the Court of Appeal said that an expert opinion should have an expert observance, or at least the findings must be based on the fact that the husband was the one psychologically incapacitated. The expert here, the doctor, the psychiatrist, only based her opinion from the interviews of the wife and the sister of the wife. Now, let me explain what happened in Andal. It changed the spectrum or the atmosphere of annulment. I'm not saying it's going to be easier. I'm just saying it's less burdensome. Here are the changes made by Andal. First, the case of Andal, as compared to the other cases, such as the, for lack of a better term, the Marcos Doctrine, relaxed the rules on Molina because they found out that the rules on Molina, the 8 requirements, was too rigid and too strict. Subsequently, in further cases, the Supreme Court said that not all cases that are for annulment will fit squarely into the Molina Doctrine. So they had to make adjustments. Eventually, they said in a later case that the court, when studying or having the trial for annulment, should take it on a case-to-case basis, meaning it should not compare itself to the previous cases or at least the Supreme Court rulings. It has to be treated individually. For example, if a guilty spouse is only giving 10,000 a month as subsidy or support for the family, Relatively, somebody who's earning only 15,000 a month or minimum wage gives a majority of his income. Hence, it is sufficient as support. But if the guilty spouse is earning 100 or even much more than half a million a month, 10,000 a month would be sufficient to say that he's not fulfilling the obligations as far as support. So it cannot be the same for each case. The most important change with the Andal case is that the psychological capacity is no longer a medical conclusion. The Supreme Court here looked at the notes or the deliberations of the Code Committee, and they said that the psychological incapacity should not be constrained or limited to a mental definition, which means that the Supreme Court here in Andal said that medical expert testimony as to the finding of psychological capacity is no longer required, but may still be offered in a petition. Nevertheless, its lack of the psychiatrist or medical expert opinion will not destroy or invalidate or have the case dismissed. How then do you prove that? The Supreme Court said that testimonies of people who know about the marriage, who know about how the guilty spouse was incapacitated, on how the guilty spouse was not able or not aware or could not fulfill the essential marital obligations. It could be the best friend of the parent or a party who was witnessed to the hardships of the marriage, or how the marriage was non-existent because of the psychological capacity of one spouse. The witness here, not necessarily a doctor or a psychiatrist, must show to the court that there was a dysfunction or the guilty spouse was dysfunctional enough that psychological capacity is evident or was evident. To reiterate, the witnesses could be ordinary citizens that will testify on the behavior of the guilty spouse. To summarize the medical non-requirement, the court said that there need not be a mental disorder on the guilty spouse. With regard to the requirement of judicial antecedents, the court said that should remain because under the law, the psychological incapacity was present or should have been present or was present during the time of the solemnization of the marriage. Meaning, when the spouses got married, the guilty spouse was already or had already that psychological capacity. But it can be shown or it can be proven that the psychological incapacity or the dysfunction of the guilty spouse only manifested or only shown or it came out after the wedding ceremony. One example that the court gave in Andal was, for example, and I'm sorry to mention this, violence or abuse against the children. Of course, that can't be shown at the time of celebration of the marriage, but of course that will come out after. The court said that the evidence of such abuse or violence against children, which will only manifest after the marriage, is a sign of its antecedents, meaning the court had the belief that a good spouse will not have that inclination to abuse or be violent to the children. The court also said on the incurability. It modified it to say that incurability is not permanent. What do you mean by that? For example, we all know, and I'm sure some of you know, some people whose marriages have been annulled and they marry again. If a person or the guilty spouse has been declared psychologically incapacitated in a previous marriage, and the ruling is that it's incurable, then that person or that spouse should not have got married again, because his psychological capacity to understand the marital obligations of a marriage is incurable. The court said here that the incurability is only to a specific person, not necessarily to the whole. Thus, incurability now is considered a legal conclusion rather than a medical or a psychological condition. The ruling of gravity from Santos and Molina has been retained. It's such show that the psychological capacity is so evident that it creates a dysfunction and creates or shows serious psychic cost to the guilty spouse. In Molina, how it modified the old Santos doctrine was that it added that the marital obligations, both as a spouse and a parent, should show that it's not being fulfilled or not being performed by the guilty spouse. The court here in Andal modified that to state that the marital obligations could be not just to the children, but to the psychological incapacity itself or the dysfunction present in the guilty spouse. The example given was the drug abuse and the failure or the non committal of the guilty spouse to go into rehab or at least fix that problem. If the guilty spouse has a drug problem and does not want to go into rehab, doesn't want to be cured of it, or doesn't want to be get rid of that problem, a that shows a nature that could lead to psychological incapacity. Another example given was showing the abuse or the drug abuse here to the children, or doing it in front of the children. That shows a dysfunction that should be considered as psychological incapacity. Strangely, the court here in Andal, as admitted by the ponente, Justice Leonen, who is a firm believer on the separation of church and state, still gave a pronouncement that the church's findings with the National Appellate Matrimonial Council of the Church should be given persuasive effect. In the sense that if a marriage has already been annulled previously or given a church annulment, that should be given some effect, some weight towards the legal annulment under Article 36. Of course, that only applies to marriages in the Catholic domain. The reasoning behind that is since Article 36 is founded on a Roman Catholic doctrine of annulments, getting or obtaining already a church annulment will already show that the church found that the guilty spouse was already psychologically incapacitated as far as the church is concerned. Therefore, presenting that as evidence here in Andal said that that should be given persuasive effect, but not necessarily a requirement. Another point in the Andal case was it bolstered or solidified the Marcos doctrine, wherein the expert or if an expert is given as testimony or as evidence for the psychological capacity, the non-interview or the failure to interview the guilty spouse should not be a bar or should not have the case be dismissed based on that. In other words, it is allowed that the expert or the psychiatrist or psychologist interview everyone except the spouse. Again, to reiterate, that only applies if expert testimony is offered by the plaintiff. As I said, it's not anymore a requirement. Let's make it clear that this video should not be considered legal advice. It is only for educational and informational purposes only. If you are thinking or want to seek an annulment of your marriage, please consult a lawyer for proper legal advice. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.